Friends, in this second session on international humanitarian law, let's take an overview of this law. For the background and genesis, it would be profitable to recall the words that describe the preamble to the United Nations Charter. We, the people of the United Nations, determined to save. Now, the preamble shows a strong view of the community of nations who decided to insert the words they, showing their determination to protect, to save not only them, but the succeeding generations of mankind beyond 1949, when the Geneva Conventions came later, and a couple of years earlier, the Charter was being drafted. From the scourge of war, which twice in their lifetime, the people who were, say, adults and a little elder, they had seen the horrors, the miseries, the violence of the two wars. So that's why the use of the words twice in their lifetime, the wars which had brought untold sorrow to the mankind. Now, this is adequate to indicate the mindset, the reasoning that led to framing of international humanitarian law instruments, about which we should see little more in detail. Further, in chapter 6 and 7 of the UN Charter would be relevant in this regard. Chapter 6 relates to pacific settlement of disputes, and the countries of the world who were signatories to the Charter and later joined the United Nations, they were of the view that the difference between the member states can be resolved by peaceful means. And the next chapter, that is 7, dealt with acts of aggression, how and when these clauses are to come into play. Article 51 accepted and highlighted the right of self-defense, and because the member states, because of their right of sovereignty, they were all vested with an inherent right or collective self-defense. In inherent right of individual, of course, it is clear that it is a threat to a nation and that nation responds against the aggressor, whereas in collective, there could be sort of an agreement, a prior uh, decision, agreement of mutual support when armed attack occurred against a member state. Now, these were the two situations that were visualized, and the third can be considered emanating from the Security Council's decision, the measures necessary which the Council could take, and that included a direction or a nudge or a push to other member states to take suitable measures in situations which are there under this article. At that stage, there were two laws which were then existing. There is a Hague Convention of 1907, and then there is a Geneva Convention of 49. Now, these two laws dealt with different situations and they had a different purpose. The first purpose with regard to Hague Law in the first situation was that how should the armies conduct themselves? Means this was more relating to the combat means or the methods of combat. Whereas the Geneva Law, which found its base from Geneva Conventions of 1949, indicated and was geared towards the protection of how people in power should be treated. Now, therefore, it is very clear, one related to the mode of carrying out armed hostilities, whereas the second talked about the protection. Now, what protection was to be given, which people were entitled to such protection, for what duration, all that is included in Geneva Conventions of 49, which we would see in detail during this series. And with background, as indicated, it can be understood that international humanitarian law is a set of rules whose purpose is humanitarian cause, and they seek to limit the effects of armed conflicts. Now, armed conflicts, as can be easily understood, involves use of lethal weapons whose effects are fatal in case of an individual weapon, and also quite stupendous in case there are area weapons. Compare a pistol or a rifle from a cannon. While one is targeted or targets an individual, the other targets an area. And therefore, in their own way, they are quite lethal. They lead to violence, and the purpose of IHL is to limit the effect. IHL cannot stop a war from taking place. However, it can limit the destruction that follows, and it protects persons who are not or no longer participating. Now, there is a difference between the two words, who are not or who are no longer. Who are not, say for example, the medical personnel who are present on a battlefield, but they are there to prepare a hospital or an advanced camp to select people. Whereas the word no longer means a combatant who was firing but then himself gets injured and he is lying wounded, perhaps unconscious. So therefore, he would fall in that category, that he is no longer in a position to participate in the battle, and the IHL takes care of both these categories, and in the process it also restricts the means and methods of warfare. These two words are very important. They should be noted. What are the means of warfare? And this would include the weapons, and how those weapons should be used would correspond to the methods of warfare. The origin of the IHL can be traced back to Henry Dunant, who was a founder, a co-founder of ICRC, International Committee of the Red Cross, and he, during the Battle of Solferino that took place in Italy, seeing the horrible consequences, decided to bring in these rules for protection of war victims, and later on, for his efforts, he was awarded the first ever Nobel Peace Prize, and that was for his role in the International Red Cross movement that was spearheaded by him, and that led to framing of Geneva Conventions. Point may come, how is it relevant to India? Why should we bother about it? Why should we learn it? Well, remember and appreciate that Indian Armed Forces are the world's second largest military because of sheer size, having more than 1.45 million active soldiers, apart from those who are part of the paramilitary forces in the central police organizations like CISF, Border Security Force, ITBP, and so on. And it is not only the workforce, the financial support provided by the state to support them is, in terms of the budget, is the second largest after the US and China. And the last figures, it is stood at $72.9 billion. It should also be kept in view that right after our independence in 1947, India has been engaged, has been drawn into armed conflicts against Pakistan in 47-48, followed by Indo-China War in 62, I am, of course, Goa operations that took place in 1960, followed by again Indo-Pak War in 65, then the conflict in 71 that gave rise to the birth of Bangladesh, and the Kargil War of 1999, and of course, very recently the Galwan Valley incidents where there was a short duration but a very fierce encounter between the um, invading Chinese and the Indian troops. Now, the Geneva Law, a word more, the Law of Geneva is a colloquial term. It refers to the body of law that mainly deal with the protection of victims of armed conflicts who are in the power of a party. That means that they may be prisoners of war, or they are lying there sick and wounded, or those who are shipwrecked, or the civilians who are in conflict zone. Now, against all these, what are the behavior rules, norms, which the other power is expected to follow? That is what is Geneva Law is all about. And purpose of this law is to provide minimum protection level beyond which there is to be no deviation, there is to be no disregard. Then what would be the standards of humane treatment, and what will be the fundamental guarantees of respect to individuals who become victims of armed conflicts? For example, the prisoners who are there in captivity, what minimum food would be given? What assistance would be given to them, say, in religious matters? How can they prefer and bring forth their grievances? Well, all this is contained in the Geneva Conventions, which is colloquially known as Geneva Law, and the body intergovernmental and at the world level is the ICRC, International Committee of the Red Cross. This is a humanitarian institution. It was set up, as I earlier said, by Henry Dunant. It's based in Geneva in Switzerland, and its mandate is to protect the victims of international and later also internal armed conflicts, which came about by virtue of Common Article 3 and the additional protocols which are there. It is to be borne in mind that the universal acceptance can be assessed and indicated by the fact that 196 member countries of the world have accepted and ratified the Geneva Conventions. Well, India had ratified these in 1949, and then in 1960 they were brought into, incorporated into our municipal law, so that the Geneva Conventions Act is an act of India's parliament. What happens if a country does not abide or respect these rules in certain situations? This may even be taken to the International Court of Justice, and in any case, the Geneva Conventions and additional protocols, they lay down that they should not be allowed to take place insofar as the member countries are concerned, any disregard of the rules. The Geneva Law, or the International Humanitarian Law, categorizes and enumerates four types of disregards, which may be shown or can be seen in the IHL text by use of the words breaches, grave breaches, serious breaches, and abuses. Now, breaches, grave breaches, serious breaches, and abuses, certain examples have been given on the slide in front of you that, well, this would particular clause amount to a grave breach, this would be a serious breach, and this has been viewed as an abuse of the conventions. So these are the four words that you may find in the IHL treaties. What happens against the individuals who disregard or who carry out a serious or other breach of the Geneva Conventions? There are different modes the matter can be treated by way of action and punishment provided by the military authorities. It can take place of summary disposal. It can be a summary court martial or other type of court martial, administrative action. Well, all these are would fall as the options by the military authorities. In certain situations, matters can be taken to the domestic courts under the criminal law procedure, and in certain situations where the domestic jurisdiction is found to be incapable or unwilling to take an action against an offender, well, the International Criminal Court may step in and can take action in those situations. This court, ICC, is or can come into effect and invoke its jurisdiction in four types of crimes which are known as core crimes, and these are crimes against humanity, genocide, war crimes, and aggression. And the ICC statute makes out as to what are the ingredients or the constituting elements of each of these crimes, and for which there is a pre-trial procedure, post-trial procedure, appeal procedure, and also, in case needed, an investigation procedure, which all can be found in the ICC statute. Briefly, as to what are the career opportunities for the students who wish to pursue further studies in international humanitarian law, they can get into litigation, they can join legal authorities, say for example International Human Rights, International Court of Human Rights, or the National Human Rights Commission, etc. They can take up academic role in teaching of IHL, as well as they can become authors, they can take up jobs and assignments in media, print, electronic, or otherwise. And also there are career opportunities in various UN agencies, for example, in the peacekeeping operations, in the UN Women, UN Child, etc., and various other bodies where there are jobs and assignments dealing with IHL. In the end, it is to be highlighted and recognized that international humanitarian law has over the years emerged as a course which is useful. More law colleges in India are accepting it, introducing it, and this contains interesting topics which carry huge potential for by way of their application and practice, so as to offer career opportunities for the students. Thank you.